Hello and welcome to the fourth talk on appeals and the public access scheme. In the last talk I talked about the notice of appeal and the concept of an error of law. I want to turn next to another important document that you may need to complete or you might need to get a lawyer to assist you with. This is the skeleton argument. Now, it's a document which is supposed to be, and I'd encourage you to think about it as assisting the court in very specific ways. It's a concise statement of the arguments you rely on. Now, the issue about being concise is incredibly important. The court values brevity very much, and if you find that you're running into very long paragraphs, if you find that you're running into sentences which are very complicated and contain a lot of sub-clauses, then stop. Shorten it, simplify it. Use simple sentences rather than relative clauses. So be concise. Define what the appeal is about. Define the area of controversy. Keep the controversy within reasonable bounds, so confine it. Don't start going on about areas of dispute which are no longer in dispute. Essential to this exercise is to use numbered paragraphs. One good way of thinking about this is that you should use one paragraph for one thought. You should cross-refer to any relevant document in the bundle that you'll be preparing for the appeal. Now, I say any relevant document, and that's incredibly important. If you're about to make a reference to a document, ask yourself, why is this relevant to the issue in the appeal, to the point of law that I am trying to establish? It may be, for example, that you want to bring in a document because it shows the other side in a bad light. That's not going to be a relevant document for the appeal, in all probability. The other thing to remember about your skeleton argument, it needs to be read as a self-contained document. So don't refer back to material from previous skeleton arguments. This is essentially a practical point, because what you have to remember is that this is likely to be the document that the judge focuses on to get a real understanding of what your case is about. Now, that shouldn't be an invitation to you to try and put every single point you can possibly think of into that document. What it should be more like is a series of bullet points which identify the documents that you want to rely on during the appeal, and also gives a brief statement of the legal points that you want to make. The judge may well be taking this document away with them from the court to read, for example, overnight. So bear in mind it's got to be a self-contained document, as I've said. I'd advise you against including extensive quotations, principally because the practice direction says you mustn't do it. So that's extensive quotations from documents or extensive quotations from the case law. So you can see how there's a tension between the idea of this being a self-contained document and not including these extensive quotations. The temptation is to include extensive quotations because then, well, the judge has got it all in one place. Instead of doing that, do cross-references to the relevant bits of the bundle, and in the bundle put a black line next to the part of the document you want the judge to look at. If you have to refer to case law authority, then the way to do it is to state the proposition of law that the case law authority demonstrates. My suggestion is that you do that first and then put in brackets afterwards the following bits of information: the name of the case, the part of the case that supports the proposition that you've just written down. Most judgments since the year 2000 have been done by way of paragraph numbers. Earlier court decisions may well not have been done like that, and so the case law has been set out in reports. Generally speaking, they'll have a page number and there'll be a letter in the margin which helps you to find the precise point in the text that you're looking for. So what you need to do is either identify the part of the authority that supports the proposition by reference to that paragraph number, or by reference to page and side letter. It's not a good idea, and the practice direction tells you not to do this, to cite 3 or 4 authorities for the same proposition. It doesn't make it any better just because there are various authorities which appear to say the same thing. And indeed, if you do cite more than one authority in support of any particular proposition, then you've got to explain why that is necessary. One good way of ensuring that a barrister, if you instruct them under the public access scheme, can get into your case very quickly is to provide a chronology of relevant events. And the Court of Appeal says that this is going to be necessary in most appeals in any event. So you might want to make sure you've done that before seeking to instruct your barrister. You're going to need permission to appeal against a county court or a high court decision, but not in the cases of committal orders or various other liberty of the individual situations which I've set out. How do you do this? First of all, you should apply to the deciding court, so that's the one you're appealing from. If you don't do that, or that court won't give you permission to appeal, then you can apply to the appeal court for permission to appeal to it. So if the first court refuses, you can apply for permission to appeal to the appeal court. So what's to lose? It's probably best to apply to both. The judge at the lower court may just say, I don't think there's any merit in your application to appeal. That's fine. You can renew your appeal application for permission to the appeal court. So you get effectively 2 bites of the cherry. Now, detailed provisions as to when you do and don't need permission to appeal are set out in the Civil Procedure Rules, CPR, Part 52.3.1. In the case of an appeal from a master or district judge of the High Court, permission can be given by a High Court judge. If you're appealing from the County Court, the High Court judge, if the decision was that of a recorder or an authorised designated civil judge, then you can apply to the High Court judge for permission. In the case of a second appeal, or an appeal from an appeal, you can apply only to the Court of Appeal. You've got to be able to show an arguable point of law or some other reason why permission should be granted. In the case particularly of case management appeals, and I'll say a bit more about this later on, you've got to be able to show that they're of they're sufficient significance to justify the costs of an appeal. So the person considering the permission application will be asking whether the procedural consequences, for example losing a trial, outweigh the need for an appeal. They'll also be asking, and you should ask first, whether it's going to be more convenient to deal with the issue at the trial or after the trial. That's in the case of case management decisions which you don't like. The procedure in the Court of Appeal is that first of all you make a written application including your grounds, and that's considered on the papers by a single judge. If you're refused permission on that paper consideration, then within 7 days of receiving the refusal notice, you can apply to ask the Court of Appeal orally for permission. So in other words, you ask for a hearing. However, one of the changes that's happened recently is if the Court of Appeal or the High Court, a designated civil judge or specialist judge refuses permission without a hearing, so on the papers, and certifies that the application is totally without merit, then you're not going to be able to apply for an oral hearing. Sometimes the appeal court will ask the respondent to attend the oral permission hearing, and if that happens, if permission is refused, you may have to pay their costs. So permission to appeal is only going to be given you if the court considers that the appeal would have real prospects of success, meaning a realistic as opposed to fanciful prospect of success, or there's some other compelling reason why the appeal should be heard. So that means, for example, an issue which the court considers should be examined in the public interest, or because it raises an issue where the law requires clarifying. So if the permission is that the court doesn't feel you've got a real prospect of success, but there's some other compelling reason, then think very carefully about whether you want to proceed with the appeal at all. The other thing that the court can do on granting permission is to limit the issues to be heard, so that if they've managed to find some reasonable grounds of appeal amidst a very long notice of appeal, which, contrary to my suggestion earlier, has included absolutely every point that could have been and some that couldn't have been made, then they can limit the issues to be heard. They'll grant permission on certain issues but not others. They're also entitled to make the appeal subject to conditions. So if you didn't observe the orders that were made by the lower court, then a condition of your being allowed to appeal may well be that you have to comply with those orders. They can be orders telling you to pay the other side's costs, whatever the outcome. You may be told you're not going to be entitled to your costs, even if you win. The costs orders that were made by the courts below may well be left to stand if, for example, you're raising a point which wasn't raised previously. I want to say a few words about dealing with the oral hearing. One of the things that you or your lawyer will need to do is 4 days before the hearing, you need to send a brief written statement of the points you intend to raise. And my advice, which I repeat, is that you should focus. I'll say it again, focus the points. Because what you have to do is to say why, despite each of the reasons given for refusal on your written application, despite those reasons, you think permission should be granted. At the hearing, you've only got a very short period of time, maybe 20 minutes, half an hour, to make the points you need to make. So it's essential that you work out what you think your best points are, and then you make them. You make them succinctly, clearly, and keep to the point. You also need to draw attention to any adverse case law or factors that you know about. Because the court is listening to you and probably won't have the other side present, then the court's heavily reliant on you. For example, you can't assume that the judge has read each and every piece of paper, so you've got to help the judge. You also mustn't assume that you can make the judge read each and every piece of paper before considering your application. The other implication of the importance of an oral permission hearing is this: if you do brief a barrister on the public access scheme to represent you at an oral permission hearing, you must be prepared to accept that they need proper time to prepare thoroughly and carefully, because the consequences of not being given permission are stark. But before I turn to how difficult it is for you if you don't get permission, here are some things which are just difficult to appeal. Case management decisions, generally speaking, you'll be challenging the discretion of the court, so you're heading then into the territory of perversity. Secondly, if the permission application is in front of the Court of Appeal and the proposed appeal is the second tier of appeal, so in other words if it's a second appeal, if you're appealing from a highly specialised area of law which has got specialist tribunals, then the Court of Appeal is going to be diffident about interfering with the decisions of that specialist tribunal. If you're refused permission, that's the end of the story. Your case on that point comes to an end. Judicial review, or JR as it's known, of a junior appeal court's refusal of permission can very rarely be available. It'll be available if there's some fundamental departure from correct procedure, or if the judge acted in complete disregard of their duty. You can't judicially review a Court of Appeal decision to refuse permission. The other side needs to know what's going on, and you have 7 days at most after you've filed your appellant's notice to serve it on each respondent. In fact, the rule is that you must serve it on them as soon as practicable after it's filed, and in any event not later than 7 days. Once permission is granted, you should discuss the time estimates for the full hearing with the other side. It's really important to cooperate over this. It's in everybody's interest to work out exactly how long the appeal is going to take and how much court time it's going to take up. One thing you can't agree variations on are the time limits for appealing. If you've got an application to vary the time limit for filing an appeal, you can do this in most cases, unless a statute says you can't, but you have to do it to the appeal court. An appeal, generally speaking, does not operate to stay the lower judgment. If the lower court or appeal court directs that the appeal should act as a stay, then it will. There are certain immigration cases in which it does it automatically. I said earlier that I would speak about amendments. You can't simply turn up on the day with a bunch of new arguments. You can't actually amend your grounds of appeal without the appeal court's permission. And the way you should go about this is, first of all, once you've realised that you need to say something new in your grounds of appeal, you should write to the other side first with a draft of your proposed amendment, so the bits of text that you intend to insert into the text of your grounds of appeal. See if the other side will agree to it happening, and the sooner you do that, the better. If they won't agree, then you apply to the court. At the same time, you can write to the other side and say, well, you won't agree to this, so can we agree for this to be dealt with by the court by way of directions before we come to the hearing, and they may agree to that. If they don't, then you can see whether the court will deal with it in any event before the hearing, or whether they will deal with it at the start of the hearing, and that's very often what they do. I'd suggest that you consider whether you need to amend your grounds early, because this gives you more chance of the amendment being granted. An appeal court can strike out the whole or part of your appeal notice or set aside permission to appeal, either in whole or part. It can also impose or vary conditions upon which you can bring your appeal. There's got to be a compelling reason for applying to strike out the whole or part of the other side's appeal notice or document. And if you were present at the hearing at which the permission was given, you won't be able subsequently to apply for an order that the court exercise its power to set aside permission or impose conditions, etc. I'm going to say something about costs, but this is definitely a point that you need to discuss with an advisor. If you're coming from a jurisdiction in which costs recovery is normally limited or excluded, then the Court of Appeal or the appeal court can make an order that the recoverable costs of an appeal will be limited to the extent which the court will specify. And the court will have a look at the means of both parties, all the circumstances, and the need to facilitate access to justice. If your case raises an issue of principle on which substantial sums may turn, then it may not be appropriate to make that type of order. You have to apply for the order as soon as practicable, and it'll be determined without a hearing unless the court orders otherwise. I'd suggest you discuss with your advisor whether your case falls within the categories where you can get protection. There is some helpful case law on this.